All right, we went a little bit over time on that break. I think in some ways, I know that when you're here for half a day, you do need some of that time. Look, this second session, again, is extremely interesting. I think there are just so many cross-cutting issues associated with privacy, and some of the questions I think that still linger are questions such as how can we best transfer personal data across borders while ensuring a reasonable level of protection? What assurances and transparency should individuals seek when asked for their biometric data? What are the hallmarks of an effective, transformative, and privacy-conscious digital identity program? All, I think, novel issues. So, again, I will be asking Dan to introduce a wonderful panel, and thank you, Dan, again, for leading this session on current privacy issues.
So I'd like to do our introductions. First, Justin is the founder and CEO. Justin Antoni Play is the founder and CEO of WireWheel. He was acting Undersecretary for Economic Affairs at the U.S. Department of Commerce during the Obama administration, and he led the negotiating team in reaching the EU-U.S. Privacy Shield framework, which later was struck down, but now it's coming back. So it's going to be back again. And Heather West is Senior Director of Cybersecurity at Venable. And previously, she was director of the privacy policy team at one of the world's largest social technology companies. So welcome to both of you. And I'd like to kick this off with a very general question, which is, what are the privacy issues that you're thinking about the most these days? Kind of what's the hot issue in your focus right now?
I'll kick us off. The funny thing is, when I was thinking about what I wanted to talk about today, I started brainstorming. And it became very clear very quickly that the actual answer was everything. We're talking about everything here. Dan and Justin and I just now were talking about how years ago, this was like a limited number of things. There were a small number of topics that we looked at and we said, that's privacy. We're thinking about this really hard topic. What are we doing? But now we're talking about everything. And so it's that intersection between different topics that I think is really, that captures my brain and my bandwidth on a day-to-day basis. What does privacy mean in the context of X or Y or Z? And then bringing it into other kind of policy questions. Alvaro was talking about how antitrust and competition come together with privacy at the FTC and other. We're seeing more issues in the context of privacy, which is to say that I'm thinking about how some of this translates and how we use kind of existing knowledge and know-how to inform data and data governance. I'm thinking a lot about what it means to have a robust privacy program and to have clear accountability and processes for your organization, for your company, for whatever problems that you're thinking about, and how you can do the right thing, think about things in the right way, build a robust governance structure that means that, well, as Brenda said, you won't get it right all the time. You have a good chance of getting it right most of the time, and thinking about how to build that in a responsible, robust way.
Heather, that was terrific, and I agree with you. Dan, I think it's a great question. And by the way, thank you to the World Bank for hosting us all here this week. And you have a fantastic team. And, the World Bank is setting an example by running a very forward-leaning privacy program, even though there's no legal requirement to do so, which is kind of a neat principle to set here and around the world. I'll cover two things just by way of observation. And I'm gonna start with an example. I want you to imagine that when you were filling out your taxes every year, okay, that there was no tax form that you had to fill out. You just got to go in and declare what income you have, but income wasn't defined. And then you would define how much you had to pay in taxes. And then you would create a form and you would fill it out and you would send it into the federal government saying, this is how much taxes I owe and here's your payment. Okay? Just imagine that for a moment. Now I want to highlight to you the way that we see privacy program management run almost everywhere. And it's one of the craziest things. I'm just going to be provocative for a moment, okay? It's one of the craziest things I've ever seen, because the general laws out there define that you should go out and assess your privacy programs, okay? But if you go to any company anywhere in the world and you start by asking the question, what is the thing you're assessing? Just what exactly are you assessing? Everybody has a different answer, literally. And I'm saying to you, within the same company, multiple divisions have a different definition of what they're assessing. Within a single consulting firm, global consulting firm, every partner defines it differently, and it's because it's defined globally by virtue of GDPR on the concept of a business process, which nobody has a standard definition of, okay? So all around the world, there is a principle of assessing a thing that you self-define using a program that you create based on principles that are vague. That is a really, really weird set of circumstances, to be honest, okay? So what I think is a major movement that you're going to see this year, I think driven by what I'm seeing out of the United States here, Colorado and California, is some standardization of what is the thing you're going to assess, and more importantly, what are you actually going to file with the government, okay? And here I'm going to focus on an unsung hero from the 1900s, Mabel Walker Wildebrand. Does anybody know who Mabel Walker Wildebrand is? Okay, so in the 1910s and the 1920s, it was virtually impossible to prosecute anybody who was in gang violence. Now, why? Because nobody would testify against them, okay? You have a gang and you're running, alcohol. Everybody's scared of you. And crazily, there was a principle that folks accused of crimes had where they weren't filing tax returns. Now, why weren't they filing tax returns? Because they would claim filing a tax return violates your Fifth Amendment right against self-incrimination. And crazily, by the way, I love this. This is bold. But they also said, hey, if I were to file a tax return and pay something to the federal government, you would never want to profit from ill-gotten gains, so I don't need to file a tax return. Now, Mabel Walker Wildebrand thought differently. And she said, you know what, we're going to bring a case on this. We're going to prosecute you because you have to file a tax return. And she won a case, U.S. versus Sullivan, in the Supreme Court in 1927. And that has been one of the major drivers for enforcement because you have a single form that you have to file everywhere, right? Everybody knows what your tax return is supposed to say. You file it, you certify to it, and now you can actually enforce it, okay? And so what I think is going to be a major opportunity, I don't know if it's going to be taken advantage of this year, but to me it's one of the greatest opportunities California and Colorado have. Define the form that companies have to file, saying exactly what they did with your data, make them sign it under oath, just like you do a tax return. And if the two states and the others that have any kind of filing requirement take advantage of that opportunity and they make the form the same, for the first time, you'd actually have something enforceable. Because to be honest, if the requirement is you assess something that's undefined using a methodology you define and you put that file in the form, there's no enforcer on earth that has any ability to enforce that. So I would say there's an opportunity in California because both California and Colorado have a requirement to actually do something and define it and have it filed with the government, that you could actually drive a lot of change. By the way, I know Dan well. Dan and I have been on a lot of different panels, so he's about to jump in and criticize me. So I'm going to, just like any lawyer, I'm going to blunt the force of this. He's about to say, if I'm acting Dan correctly, listen, what are you going to do with self-declaratory statements, okay? You just declare that you did it right. There's no teeth to that. And I think he's right with a band, even though he hasn't actually made the point yet. He will be right within a band. To be honest, if you have to file something under oath that says you did something and everybody has to file the same form, you can actually start holding people accountable. And I think that would be a huge, huge change. And you're not seeing a ton of this in Europe because everybody is creating their own forms and there's no standard form, and not even country can agree on do. There's no standardization anywhere. And we'll put it to companies too. It is very difficult to implement a privacy program, even if you're trying to do the right thing, if you have no idea what is supposed to be. Like, nobody has declared this is the thing you have to create. So that's the first major movement, and I promise I won't go any further other than to say the focus on ad tech and MarTech here in the United States is going to change a lot. It's not going to change in 1 year, but it's going to change a lot. And the way I would say it is, as of January 1st, 2023, ad tech and MarTech is a regulated industry now in the US, especially under California law. I would just think of it that way. And I think that's going to drive a lot this year.
So, well, I guess after hearing Justin's remarks, there's that old where like the only certainties in life are death and taxes. Well, now I can say it's death, taxes, and profit. I mean, I agree on the accountability point that, having, telling a company just do protection impact assessment and just leaving it at that really doesn't create enough accountability. Having it filed with the government does create more accountability because now someone's going to actually look at it and really be able to scrutinize it. I think one of the challenges, though, is, what does it mean? What are the standards that are going to be applied to these? The quality of them. So I think one step is to have accountability, but then we also need to think substantively, what does a good privacy program look like? And what are the metrics that we're going to look to evaluate that? Is it that, hey, as long as you, fill out forms and you have all this paper, it's good? Or do you really look at, how good is it? Because how do you do a privacy impact assessment? I always say, you need a concept of privacy to do that, because a lot of times, a privacy impact assessment is just the data is encrypted and there's access controls and therefore we protect privacy. There's so many pieces to privacy, so many components. It's such a complex concept and a lot of debate about what that is. So I guess thought would be, how do you build a privacy program? And then ultimately, how do we evaluate whether it's any good? What do we look at for that?
I love these questions because at the end of the day, I work at a law firm, but I'm not a lawyer. And I care about compliance, but I care about building the programs that get the things right more. The compliance can follow. I think that when you're thinking about building that program and thinking about backing up and saying, okay, we are well in the world of privacy, we are well past the point where someone stands in a room and says, that's good and that's bad, and that's good and that's bad. Which I think we were doing when we were paying attention to particular practices. But when you step back and you say, what is the process? Let's document what the process needs to be. And instead of thinking about good and bad practices, let's talk about risk management. And let's talk about the context of what that we're operating in, the context of services we provide, the context of the people we're interfacing with, and putting that on paper. And maybe it's not all in the same form yet. Wouldn't that be the day? If we said this is the shape of our privacy program. But you can start looking at things like the NIST privacy framework or other places that say, aha, how do you do this? And how do you do this? And then you can point back to it and say, we did our best. And that in and of itself, I think, goes a long ways for a privacy program. Obviously, there are some players whose privacy program is going to be the subject of more scrutiny than others. And those folks are really good to look at and say, aha, how are you doing it? And then you can decide which piece of it you like and which piece of it you don't. But I think that sitting back and thinking proactively about that is such a big piece of this puzzle. As companies have sat back and said, we need a privacy program, what does that mean? They have been coming up with it from whole cloth. There's been an evolution of what that means. I think the other piece of this that I will say is that when you're thinking about that privacy program and that accountability, a huge piece of it is building agility and robustness into that. You are not going to come up with these processes once and decide, aha, I have it figured out. These are questions that are going to continue evolving over time, and they should. Suddenly we have ChatGPT, we have all of this generative AI. Do we have to think about that differently? Probably not. But do we need to tweak the way that we're thinking about this and tweak the way that our program evaluates new processes, new procedures, new processing? Yeah, probably. But I am firmly of the belief that there's nothing new under the sun, but obviously a theme so far is that this is all malleable still. We are figuring this out and we are working on it, and so building that into a program is one of the things that I think a lot about. How do you build it so that it stands the test of time?
No, Heather, I mean, I think that's exactly the right framework. I mean, you and I are going to agree on a lot of things today. I would start with almost everybody with the following if I were trying to be just how we talk about it with our customers. If you think about the focus that's just happening on the way you engage with people who visit any of your websites or channels as one of the first places you should look, it's been really amazing to see that once you start focusing on your ad tech and the MarTech and the way you're engaging with your customers or visitors, even if you apply basic privacy analysis to those things, they start to raise questions. And this is an example. California has started with a lot of their regulation. I'm going to come back to California a fair amount because I think that state is going to drive a lot, not only here, but around the world in the next year to 2 years. I do think Colorado, Virginia are going to have voices, but California really seems to be ahead of the game. So, the way that websites and other technologies were built, they really were about when you land on that site, data is going automatically from that site to third parties immediately, okay? Now, you don't have to be a privacy genius to be worried about that, like if you just think about it for a second, because there's no governance on that, really, right? It doesn't actually pass. Let me just give you, I'll use hypothetical shoe company. I'm friends with a lot of the folks that are at the shoe companies, and to be honest, they hate it when I use an example using a particular brand. So let's just call it shoe company. You land on the shoe company site because you're interested in a new model. Well, starting, let's call it 2 years ago, I would bet you money that the minute you landed on that site, data about you, based on your what are called probabilistic IDs, your IP address, your user information, your user object information, was immediately shared with most of the social media sites, and it didn't actually ever pass into the shoe company. You know what I mean? So it's an odd flow of data. They're visiting your site, you're responsible for that site, you care about your customers. If you talk to any marketing person and you asked them at that shoe company, are you selling data? They'd be insulted. Of course not. I would never sell my customer data. I would never share it without governance, when literally 100% of the people visiting that site, their data was going to a whole slew of third parties, okay? Then the next question we get on a really regular basis is, well, when we're collecting choice or opt-outs, of consumer choice, why would we collect those opt-outs without making somebody identify themselves, right? Which is a reasonable question. What am I going to do with it? If somebody comes and opts out and they've opted out based on their anonymous IDs, their IP address, what are we going to do with it? And if you just merely ask the same question back, when somebody visits your website and they haven't identified themselves, are you still advertising to them? Well, yes, then you need to opt them out of that. It's the same analysis in reverse. So I'd say the flow of data in ad tech and martech involves a lot of flows that are, like, if you think about it, ungoverned the way we think about privacy. And I'd say the California focus on that one issue is probably going to change a lot of the ways we just govern that problem. And Dan, I think that the only other comment I would make on this is the ad tech, martech industry is like amazing once you just dig into it. It's just amazing the way they, to be fair, a lot of the things we love about the way you interact with different things are driven by the fact that they personalize their experience to you. And you have to give credit to that. In other words, when I go shop for a book and I go to a retail site, I do kind of like the fact that when I shop for the book, it recommends other books I like, and I often buy the books that they recommend, and then I like the books, right? But that's personalization. And what you're likely to see in the next couple of years from the ad tech, martech side is retail media networks that are based on almost every retailer's site, okay? So you're starting to see grocery stores, when you go shop at a grocery store, in their store, they're actually serving ads to you from the things that they're selling at the store. That's a retail media network. You've gone to the grocery store to buy your groceries, but you're actually getting ads from the grocery store chain for other products that want you to buy their store. That's advertising to you based on your behavior on the site. That's an amazing kind of crazy concept. So I guess I'd say to you, Dan, there's a lot in terms of the privacy program that I would really defer to Heather in terms of some of the principles she set out. But I would focus right now on your marketing and your marketing stack and ask about not sale of data, but exactly how are you sharing data in order to make your marketing program better? That's the best question you can ask.
And to build on that a little bit, sorry, I will just hop in again. I think that there are two pieces of that are really, really interesting. Yes, you have to dig into the technology. How does this really work? But that goes to some of, you have to map your data flows. You have to think about how this is working. But a more fundamental piece of what you were saying that I think is important is that a lot of the issues we're grappling with are a mismatch between what people expect from their interactions online and how the technology was designed in the first place. My background is actually computer science and cognitive science. As I said, I'm not a lawyer. And so I come at this and I'm like, well, of course they're doing those things. That's how the protocols were designed. And then we have to back up and say, oh, okay, maybe that's not exactly what it was designed for. I don't think they were thinking about marketing tech and these vast networks of information sharing that go to tell me which shoes I am going to love and are often right. And when they're right, I love it. When they're wrong, it's weird. And so there's a question there, if you're designing your program, you need to be talking to the techies. Who built this? Who can tell you where the information really is? And you need to be designing these interactions in a way that I, as the shoe customer, as opposed to the privacy expert, I get to go do what I want to do on your website at the same time that you're respecting my privacy without making me click through 5 million buttons to get to those dang shoes.
I think you both are really interesting points, and if we want to map, like, okay, let's see, we want the consumer not to get unexpected things, which I think is good. One of the challenges is there's a lot that's unexpected, and it's harder and harder with modern technology for consumers to really kind of understand what's going on the back end, and to really know what might happen. And I think, people like ads until they don't like ads. Sometimes it's great, sometimes it's not so great. Sometimes it's creepy, sometimes it's not. And it's really hard to get to that. I don't think ads are inherently bad, but how do we separate the troublesome parts from the good parts? The law, I think, often tries to not want to go there. It doesn't want to look at harm and risk and use. It tends to want to just make a kind of more of an abstract type of way, or let's just define sensitive data. And I actually wrote a piece saying I'm not sure sensitive data works in a big data age. Everything can give rise to inference of sensitive data. So everything is sensitive data. But that's a whole other conversation. But when it comes to harms and risks, determine when an ad is harmful and when an ad is helpful. Obviously, the ads are going to make mistakes. It's not always going to be right. You should say, well, it's always bad if they make a mistake. If it's just, you dump something in a privacy notice and that the consumers never read, that really doesn't solve it either, because people don't read them, and so we can't do that. So we need to figure out, well, what are okay uses and what are uses we don't want. I think a lot of the solutions I see are kind of, well, let's just stop the ads or do something that makes it impossible to deliver the ads, or really hard to do it, or do nothing, or do something meaningless, like, let's just throw up a cookie banner where people click accept just to make the thing go away. Not because they want cookies or do anything, because you don't want to go through the 1,000 different, do you want every flavor of, more flavors of cookies than Girl Scouts around the world could sell. I just want to see the website. I don't want to deal with all that. So I'll click accept. I don't really want the cookies. I just don't want to be bothered. So how do we deal with that? And ultimately, I think someone has to make a decision, what is good and what's not good. And then, so if we go down that road, who decides, and how should the law regulate this? Should someone be saying yes and no to things? Should we leave it generally to the companies? Because a lot of the law typically says, well, we don't want to do this, so we'll just they'll just say it in the policy, and then if people don't like it, they can opt out. But we know that doesn't really work. So what do you do?
You ask whether someone should say yes and no. Absolutely. Someone should be saying yes and no, except one someone. It's a lot of someones. And within this ecosystem, you're talking about you're talking about the companies, you're talking about the NGOs, you're talking about the users, you're talking about this huge network of people. And we are all people making that final call. We don't have AI that is making the call for us yet. And I kind of hope that we wait a while before we think too hard about asking something like ChatGPT to make that call. Because I think, as you said, Dan, it's a solid C student. The actual answer, and this is a little bit of a punt, is that the important part of this is really sitting down and understanding the people that are impacted and why they're impacted and how. Because at the end of the day, what I look at and I say, this is good or bad for me, is not the whole picture. And we seem to, I think, as the privacy community, have moved well beyond the idea that there's someone in a room who makes that call on their own. There is a process, there is a discussion, there is someone, and many someones who are involved in that conversation about whether or not it's good or it's bad. But at the end of the day, a lot of this, we are making decisions about systems that make a guess about me and my shoes or my books, or whether I'm going to be a good employee, or whether I get health care, or any of these decisions of greater or lesser impact. And we are thinking about what that looks like. And my cop-out answer is have the conversations, a lot of conversations, so that when you're making a guess about whether these systems that are making a guess based on data, it's a good guess. And we're not going to get it right all the time. The only way to get this perfectly right is to ban it all. And then we'll get it perfect because we just won't do it. And if we've decided that that's perfect outcome, great, we got our A. But the actual, for me, the goal is to have progressively better conversations and make progressively better guesses about who benefits and who is harmed by these technologies. And if we do that and we continue to move forward, then I'm going to be happy. Are we going to use more tools and better information about the impacts? I hope so. And are we going to pay more attention to the parts of society that maybe haven't been considered in the same way? I hope so.
No, I mean, Heather, you've clearly run huge programs and been part of it, so your insights are critical, I think, on these issues. And if I were to try to build on what Heather just covered, I'll start with California. What is California doing as a starting point, and where are you going to see enforcement for the next 6 months? There's an enforcement decision that came out in California in August of last year against the manufacturer of makeup, Sephora. I don't know if you all have heard of this, but it's an important one. And what they did there is, what the Attorney General in California did there is, Sephora, if you look at the complaint, was sharing data from their website out to normal marketing platforms that are extremely widely used. There was a pixel that went to a social media platform, and then they were sending data to one of the major search engines to help them understand analytically what was going on the website, okay? I would bet you 90% of consumer brands are using something similar. California said, number one, because Sephora took the position, that's not a sale of data. We're not selling data. The sharing of data for the purposes of improving our ads, measuring the performance of our ads, frequency capping, all normal techniques, they said that's not a sale of data. And California said, no, it is. It is a sale of data. And they fined them a little over $1 million for this site. And they said you have to do 3 things. First of all, you have to wrap all that automated marketing technology and make sure it doesn't fire if somebody decides they don't want it. That's a simple principle. By the way, there's a focus around the world of getting rid of pop-ups from a user experience perspective, as Dan was saying. People hate them. They interrupt your user experience. It often throws up like 50 choices into the middle of it and do anything until you go on. And let me just say, as a human being that walks the earth, okay, how many people do you know that know what a cross-contextual behavioral ad is? That's not someone with. I wasn't born with the knowledge of what a cross-contextual behavioral ad is. So you get a choice. Do you want a cross-contextual behavioral ad? I don't know anybody that knows what the heck that means. How many people do you know are going to look at that and then go look up what a cross-contextual behavioral ad is? So these choices, as Dan are putting up, California basically said, don't interrupt their consumer experience. Get rid of the pop-ups. Make it easy for them to come and make the choice. And most importantly, you have to implement this new technology, a global privacy control, so that you set the choice once in your browser of like what you want to happen, and it drops that without you having to do it on every site. That's a starting point to what Dan is getting at. And I think between now and the middle of the year, you're going to see California very reasonably and aggressively enforcing this and say you have to start changing the way you get permissions. What I'm worried about, Heather and Dan, and I don't know either your perspectives on this, by mid-year, with the 5 states starting to come online and California's second version, there are something between 9 and 32 new choices that have to be presented to a consumer. That is a lot. That's a lot. And even if you try, Dan, to explain every choice and had a little animated cartoon that said, like, here's a contextual ad and here's a cross-contextual behavioral ad, I don't think anybody's going to watch them. So we see a lot of companies trying to do the right thing, trying to figure out how do you put this up, how do you make a better user experience, how do you share the information. But when you start to getting to that many granular choices that are mandatory, from the human being side of it, I'm worried that people are going to get frustrated, overwhelmed, and they're going to just start doing what Dan suggested, which is just click through it and move through it. So I don't know that I have a great answer. I do know a lot of people are trying from a user experience perspective to make this better.
And it's incredibly hard, but like making sure that this is usable and respects people, not checklists, is really critical. 32 choices is a lot. And then actually when you're talking about the company implementing it, and I love, by the way, that we're doing the government piece and the regulatory piece and then the company piece, and it makes this a very nice pairing. Like company side, fragmenting their service into 30 to like different choices, and then all of the permutations of those choices, and what does their system really do? Like, that's actually hard. So it's hard for everyone. And my suspicion is someone's going to come up with a good way to do this, whether that's kind of the global privacy control or something else. Maybe it's you. But putting that burden on the user, on the people who are using your website, is just bad for everybody.
No, I agree with you. As I said, I'm empathetic to all of the parties in this thing. The government, I think, especially in the States, they're thinking about the right thing. I was looking at they have this out-of-home advertising. So you think of it as like a billboard company, okay? Well, billboard companies are often now linked to be able to retarget you based on whether your location data shows that you saw the billboard. How many people knew that? Like, not many. And some people don't feel that comfortable knowing that, hey, I don't mind, billboards are public and I know I'm going to see them. But I don't think many people realize that when you see the ad on a platform later that happens to be the same ad that you saw on the billboard, the reason you got it was that you drove by the billboard and somebody knows that you saw that billboard. And a lot of people wouldn't feel comfortable with that, right? So, but how in the world do you put that choice to a person? I don't have an answer to that. We are testing a lot from a UX perspective, but the complicating effect is what you both have really identified. People like some personalization. And there's some personalization they don't like, and it gets back to a quote that comes up in law school. You kind of know it when you see it, but it's hard to define exactly when it's crossed the line from being a comfortable personalization to an uncomfortable personalization. That's my perspective right now.
It's really tricky because even with the global, a lot of sometimes I want some cookies from sites. I don't want to have to log into Amazon every time. Sometimes I want the data to be shared. Like I would like it if I go to Uber and it would just say, okay, I know from this other data on your phone that you're going to go to the World Bank today. So I could it would just say first thing would be World Bank. But it doesn't do that. I have to type it in and whatever. But it'd be nice if it just knew it. And it could if it got more data. But the problem is there are other times where I don't want it to know it. But how do you know what that's going to be? And if we then have to the consumer has to make the choice in each individual situation, well, that doesn't scale. So that's sort of the big problem. If I know it when I see it, is so well, how do you know it when you see it? Because people have different views, and then different sites operate different. So it's not a one size fits all, which is the real challenge. Is how do we create a rule set that's really going to best capture all this? I think this goes not just for businesses, but just generally for privacy for all organizations. Has this large meta issue of how do we regulate this in a way that, is not so general, and I think this kind of general regulation of just kind of put something in a policy, do the right thing, create some documents, and call it a day, doesn't really work. But then if we're going to drill down to something that does, it's hard, because there's a lot of very difficult choices and also different views of the harm. Some people think ads are much more harmful than other people. Some people think ads are annoying, but not necessarily that harmful. And then there's different kinds of ads. Sometimes some advertising is okay. Some advertising is more manipulative, and something Ryan wrote about. When something gets too far, and how far should an ad go? How much of a person's behavior should an ad analyze? And when is that crossing a line? And that's tricky, because what is the line? So that's where we are.
Dan, another interesting discussion. Thank you also, Heather and Justin. There are some questions, so I'd like to pose a couple, but I apologize in advance as we're running out of time that we won't be able to address all of them here. However, I'm going to ask the team to take note of some of these, and maybe we can get back to you. But there, let me just start off with one question. If you had a magic wand and you would like to see one change happening in organizations to manage privacy risk for their stakeholders, what would that wish be? And this is for all three of you.
I don't know why we're starting in the middle. If I had a magic wand, I would ask organizations to bring privacy in at the beginning of their thinking. We can all scramble at the end and say, oh no, maybe we can put this control in, and you were talking about kind of wrapping some of the marketing and ad tech so it wouldn't fire. But if you had been thinking about it, and if you'd known that requirement earlier, or you thought about that requirement earlier, you could have designed it all differently. And sitting back and saying, wait a second, with a diverse team full of thoughtful people whose job it is to spend some time, like you're not racing to the finish. Spend some time thinking about how to design this right. It'll make it easier for everybody in the long term, and hopefully it will serve people instead of just trying to exploit the really cool thing that the network does in order to get a little bit more data out of someone.
So I would say that, if I had a magic wand, I'd make them all organizations should buy my books and read my scholarship.
There you go.
But in all seriousness, an answer that's actually not too far away from that, which is, and it goes to your answer too, that when they're thinking about privacy, before they just kind of launch in and start doing stuff, and I definitely think the beginning of the process is to actually think about what privacy is. What are the problems you're trying to solve for? What are the issues, so that there's a complete understanding of privacy? Because I just see time and again folks think, oh, we'll just address a couple things, and then everything else is ignored. So you really need to think broadly, and even there's privacy, but whether you and Ryan, I have this ongoing debate about what privacy is, and I think you have a much more narrow definition than mine. I kind of think privacy is almost everything, but with some limits. Ryan wants to police those limits a little bit more. But generally, I think for organizations, all the problems, like we shouldn't leave anything off the table. Any kind of harm that could be created by what you're doing, you should think about and figure out how to address. So I think it's really important to spend the time thinking about that, which has to be done early on. So if that magic wand, and that does involve, I guess, getting my books and my scholarship, but also that of a lot of other people too.
Are we allowed to just endorse? Like, wire wheel? I can throw that out. I didn't even realize that was an option. I should have had wire wheel everywhere, Dan. If I were to wave a magic wand for businesses, it's a parallel to what Heather and Dan covered. I would say start with understanding what are the 4 or 5 problems you want to solve that year. Like literally, what do you want it to look like? And the reason I say that is right now, almost everybody's website in the United States has to change in the next 6 months to a year. They don't want cookie pop-ups. You have to have a different way to receive the data. Interacting with your consumers and people visiting your site and making sure you actually have governed the way stuff works, to me, is a really high priority because it's just a regulated thing now. And second, I would say we go into a lot of businesses or organizations, and there's been this theory put out there that the only way to solve privacy is to literally boil the ocean, discover all of your data, then go and build a model on top of the data, and then you can be compliant. And the truth is, the explosion of data inside of organizations is arithmetic. It's not something you can do that way with a reasonably sized team. And so trying to go boil the ocean and discover all of your data without understanding what is the thing you want to solve, we've seen that drive people bananas. Because I'll just give you an example. If you went to discover data in a moderately sized web application that your development team builds, chances are there's more than 1,000 data elements in that one web application that is arguably personal data, because it's the logs, the telemetry, the account. So when you do that, you now have 1,000 data elements, and you have to do something with it, and that's not even your highest priority. So having a strategy that's actually tied to your risks and then understanding your resources and going to tackle those high priorities, you can accomplish a ton. But the boil the ocean approach, given the growth and the amount of data in cloud, SaaS, interconnection platforms as a service, huge data lakes, it's an impossible task. So that would be my magic wand.
Justin, that's music to my ears, honestly, because that's exactly the approach that we've been talking about with the team a lot more, because people's ability to absorb multiple challenges that organizations are facing, right, is limited. We have to understand and appreciate that, and not everything can be around privacy. I think we're also a bit realistic, right? So I think that's a great tip, and thank you all for your wonderful suggestions again. I would like to introduce David Satola here. David, who's the lead counsel, technology and innovation, to bring a little bit of the bank's perspective on this. So David, welcome.
Good afternoon. Thank you very much. Delighted to be here. I have the improbable task of summarizing the bank's operational approach to these issues in 5 minutes. And so, uncharacteristically, I actually wrote it down last night, timed myself, and so I'm going to read it, which I ordinarily would not do, to fit within the 5 minutes. So let me set the stage a little bit. We've heard from others this morning that the data ecosystem in which we inhabit today is unrecognizable from what it was 5 years ago. We live in a world, as everyone here would acknowledge, that's dominated by data, and our personal data is an unimaginable miasma swirling around the globe that we're trying to control. Very difficult task. Within that context, there is a trend, I think, in data protection around the world that is one that's based on individual rights. It's a rights-based approach. The GDPR, which we heard about earlier today, was a first mover or a market leader in establishing these rights to protecting personal data. In the intervening 5 years, we've seen countries around the world adopting similar legislation. Just not off the top of my head because I have it written down here, but just a few examples of some recent laws that have been adopted: Sri Lanka, Brazil, Kenya, Rwanda, Panama, loads of others. We also know that China adopted a data protection law for the private sector that looks a lot more like GDPR than it doesn't, which would surprise a lot of people, I think. And we know that there are loads more countries who are about to adopt laws that look a lot like GDPR as well, and amongst those are Somalia, Ethiopia, and others. And then, as we've heard just now, closer to home, we have state laws from California, Colorado, and Virginia that are about to reset that landscape. Our 2021 World Development Report, called Data for Better Lives, situated this data protection issue as part of an evolving social contract around data, and that this fits into a trust framework that, I mean, we've talked about obliquely here today. How do we encourage people to participate in this global data economy? Do we give them how much trust do we give them in the system to make it work so that they do participate, and where do the limits to that exist? But the WDR did posit that the trust framework, the social contract, and the approach to data protection was a rights-based approach. The WDR also recognized that data protection alone is not sufficient, that it's part of itself a legal ecosystem, including e-commerce laws that govern the transactions that we do online, and cybersecurity and laws that combat cybercrime to assure the integrity of the infrastructure and the data. And that these in combination are integral to the economic development work that we do with our country members in order to encourage participation in the global economy. It's a bit abstract, so let me give you a couple thematic examples in the time remaining. First is our Digital Identity for Development program, ID4D. And it was the first initiative in the bank that I'm aware of that featured in its projects a very deliberate look at data protection. When ID4D started in 2015, which predates GDPR by a little bit, it was really driven by the Sustainable Development Goals, the SDGs. And the problem that we faced there was, now we have a UN mandate, a global mandate from the member states saying, go forth and do digital ID. Didn't tell us how, didn't tell us what protections to put in place. We reckoned, as we got into this a little bit, that because it was digital, that allowed us to incorporate protections, technical protections that didn't exist in the analog world for analog-based ID. But we knew we were dealing with a lot of sensitive data, data of vulnerable groups. So we insisted that all of our ID4D projects in the intervening years, there have been around 45 or so, include a robust due diligence on data protection, include components that would address gaps in legislation if they were found through the due diligence. And we issued at the same time something called the Principles on Identification for Sustainable Development, which were endorsed by 30 multi-stakeholder groups, countries, UN organizations, foundations, and NGOs as well. And we developed a legal due diligence tool called the IDEEA, ID Enabling Environment Assessment, that we use in every project. And then came COVID. And in what was perhaps the single biggest global exercise in data collection, possibly since the time of Caesar, the response to COVID in those early, very scary days required collecting and processing vast amounts of personal health data. I'm proud to say that in the dozens of countries where we provided financing, and in the millions, if not billions of dollars that were poured into the COVID response, the bank systematically took measures to ensure that all the personal data that was collected by our member states would be done in a context of minimal data collection if they did have a law in place, even in that emergency context. And I can tell you the internal debates about that were pretty hairy, and But in the end, it was recognized that that was the right thing to do. And eventually those same protections were extended when we started financing vaccines. But challenges do exist, and they include capacity building. We didn't really talk about that very much today, but capacity building around these new laws, around these institutions that are created by these laws, both for policymakers, legislators, judges, lawyers, civil society, NGOs, and people to understand how they relate to this ecosystem. Operationally, we do address data protection in our project due diligence. We have something in the World Bank called the project cycle, which is from project identification to appraisal to negotiation to implementation, and usually the project cycle takes anywhere from 5 to 7 years. So throughout the project cycle, we address these data protection issues through due diligence, designing project components that are fit for purpose for the country, and then through the supervision of the implementation of the project. In our advisory capacity, we work with our counterparts and with our internal task teams throughout the project cycle to make sure that the recipients can achieve their project development objectives within the context of protecting personal data. But let me leave you with this thought, and I'm nearly done. We know that Google is a search engine, but it's really a data company. And Facebook is a social network, but it's really a data company. Amazon, someone mentioned Amazon or a footwear company or something earlier. These are they are retail consumer online services, but really they're a data company. And my hope is that in the near future, the bank will embrace the fact that in addition to being an international financial organization, it's also a data organization. And with that, I thank you.
Thank you very much, David. I think there was one question from the online audience. You could choose to answer it later, but the question is, in what region has the World Bank been focusing on most when it comes to privacy and digital development projects, and why?
Well, very quickly, we have digital development operations, and therefore that include data protection components in all of the regions that we serve.
Thank you. I knew you would be very quick. So I want to really welcome Chris Stevens, who's our Senior Vice President and Group General Counsel for the World Bank Group. Chris, thank you very much for coming. Sorry we're late. You can choose to do it from there too. We have got Chris to do some closing remarks, and then I'll say a few words.
Thanks, Riaz. Good morning, good afternoon, depending on where you're participating from. We've reached the end of the program for the Data Privacy Academy segment of the Data Privacy Day 2023. We've had some terrific discussions that have touched upon how increasing digitalization and the development of technology are reshaping the data privacy landscape. And as Lakshmi said at the outset, how AI and machine learning are both impacting development and at the same time increasing risks to vulnerable populations and raising the stakes on issues of data privacy more generally. We've had the pleasure of hearing firsthand from global data privacy experts and World Bank Group senior management on the power that data has to boost new technology and indeed to shape the future of the bank. It occurred to me when I was sitting back there that, as many of you know, the bank senior management and the board are engaged in redefining the mission of the bank. So while we're talking and have been for the last 15 years about twin goals, there may be triplicate goals, the newest one delivering global public goods. And that involves the aggregation of all of the data and information we have into analyses. So we are, in fact, as David just suggested, becoming very much a data bank. And with that, we need to be mindful of the need to rigorously protect the privacy of vulnerable people and communities in developing countries. We've had some fascinating discussions that have also touched upon data privacy and how that intersects with the public trust in international institutions such as the World Bank. So I hope this event leaves all of us with plenty to think about, lots of ideas to reflect upon, and the importance of data privacy and how it can be, issues and risks can be identified, mitigated, and integrated into both the bank's operations and to our own everyday lives. Professor, it would seem that privacy is not dead. So this annual flagship event is a great opportunity for us to come together and build and expand our network of data protection and data privacy experts, and to learn from each other and to deepen our awareness of the importance of data privacy, programs to identify risks, programs to mitigate those risks, and the importance of compliance and training to stay on top of this ever-changing area. The event's also an opportunity for compiling the organization's experience and expertise in areas of strategic importance, drawing from important lessons learned and honing them into innovative and practical solutions to address risks and enhance compliance. So I'd like to thank all of our distinguished speakers, both who participated in person and virtually. That participation really has been the key to delivering a successful event. I'd also like to thank the Data Privacy Office for organizing this terrific event, and Teach Privacy and Professor Soloff again for co-organizing the Privacy Academy for the second consecutive year. Thank you, Professor. In an era of multiple overlapping crises, it's important that well-positioned international organizations such as the World Bank exercise our convening power to continue conversations for the benefit of the millions of people who have placed their trust in our organization. And finally, thanks to all of you for participating. We look forward to your feedback. Please enjoy the lunchtime talk with Professor Ryan Calo that follows this segment. And with that, Riaz, I'll turn the mic back to you, and thank you for chairing this segment.
Thank you. Thank you, Chris. Thank you, everyone, for being here today. I just want to personally thank Arune Madhar and her team for organizing this event. As you know, a lot of organization goes behind such a day. Everyone online for staying with us, I hope, for most of the half a day. And of course, to all of the panelists who have been really, really insightful, and Dan himself. So I think lunch is out there with some lunch boxes. Please feel free to grab that. And then I think come back in 10 minutes or so when there will be another session hosted by Ryan Calo, as Chris mentioned. So take care. Have a good day. Bye.